Good evening, Captain Retired Matt Edwards here on the 23rd of March 2023 with my weekly observation post Facebook Live report. Now, I'll start off, I guess, with my numbered list that I'm continuing on with. I think I'll post that again soon because I haven't updated the list. I put it in the files part of my observation post group. So I like to be totally open. So all of the stuff I put there is there for you if you want to read it. Number 221, and I got to be honest, I'm not exactly sure what I meant when I put down burden of proof. That's the only thing I put into my notes, but I'm pretty sure I can expound on what I think I meant. Now, if someone's going to allege something happened, then they have the burden of proof to prove that wrongdoing happened. So, for example, if someone hits you and then you sue them in tort, you have the duty to prove that there was a duty of care, that the duty of care was breached, and the third thing is that monetary damages happened. Well, if the government is going to make like a law, for example, and they're going to say that they're going to protect pensions, like Pension Act Section 30, or the Canadian Forces Superannuation Act Section 83, or the Canada Pension Plan Act Section 65. Now, those laws are supposed to protect the person's property. Now, you might say, how is the Pension Act property? Well, the Pension Act is a capital payment to replace the capital loss when a person is injured in military service. It's a replacement for a lawsuit in tort. It's the same thing as damages. So that makes it the veteran's property. So that's why Section 30 is there in the Pension Act. That's supposed to protect the pensioner's property. Of course, now the government has a little bit of say on it, because if they don't award it, then, it's hard to get your property back when they don't recognize something as, legitimate. Now, that'll come up later, because what I plan to do tonight is I've written a letter. I've done 2 drafts so far. I've written a letter to my Member of Parliament, and I'm going to ask for his support on 2 issues, and I'll go into them later. Anyway, number 222, the Canada Pension Plan Disability Flat Rate. Does this benefit anyone? Or does it benefit the right party? Now, I've talked about that many times, and I'm not going to apologize for bringing this up again, but what happened is, and I'll explain, the Canada Pension Plan Disability is made up of 2 things. The first is an economic portion, and the second one is a flat rate. Now, the flat rate used to be a lot less than the Quebec Pension Plan Disability had. So in 1987, the government increased the Canada Pension Plan Disability to match the Quebec Pension Plan Disability, and it tripled the flat rate. Now, the flat rate is currently about $500 a month. Now, when they did that, the companies that were administering insurance plans, and the provincial governments mostly, they perked up their ears. And before that, they had left the Canada Pension Plan Disability alone, for the most part. After the flat rate got increased, everybody jumped on the bandwagon, and then they started clawing back the Canada Pension Plan Disability because they wanted the flat rate. But I propose, I stipulate, I state that the flat rate is meant for the disabled fucking person, not some goddamned insurance company. So that needs to stop. Even if they could pull some rabbit out of their hat and say that the Canada Pension Plan Act Section 65(1) doesn't apply, and they can claw back stuff, they can't touch the flat rate meant to assist the disabled. That's not the purpose of the Canada Pension Plan Act. It is not meant to make large and successful, profitable insurance companies richer. To say that it is insane. So I look at that as a fallback position, okay? They might pull a fast one, bribe the judges or something else. But the flat rate has to be taken out of any clawbacks by SISIP Manulife, Sun Life Treasury Board, Veterans Affairs Canada. Anybody who wants to take the Canada Pension Plan Disability into account can only assert a claim, in my opinion, on the economic portion. That seems to be a no-brainer. 223, because my letter's a couple of pages, I don't want to be beating these points to death. Repugnance / interjurisdictional immunity. Laws are supposed to agree, not counter each other. Now, I've been looking up this stuff because the government wrote laws to say that the Veterans Wellbeing Act regulations, which is a law, can take into account the Canada Pension Plan and reduce the income replacement benefit. But Canada Pension Plan Act Section 65(1) works with Financial Administration Act Section 67, so you have two laws that state Veterans Affairs can go fuck itself. Now, when you write laws, you're not supposed to write laws that disagree with each other, because it causes us to shake our heads and say, are you fucking nuts? But normally it's between two different states, like the provinces versus the federal government. So the provinces might make a law that disagrees with the federal law, or the federal law might disagree with provincial law. But the feds have taken it to a new level. They have created laws at the national level that disagree with each other. This is crazy. They should be able to do what's called due diligence. And when they're writing a law, a new law, they check with the old laws to see if they're breaking them. Now, I don't think I'm asking for the moon here. The Department of Justice should look at, review the existing laws, and then they should say, you know, we can't do that. We can't write Veterans Wellbeing Act Regulation Section 22 that says we can take the Canada Pension Plan into account and reduce, you know, Veterans Affairs liability so that the taxpayers can save money, when we have another law that says we can't do it. Right? So why are they getting away with it? Because who's going to take them to task? Okay, I'll bring in a semi-related example. Putin has been ordered to be arrested by the International Criminal Court for kidnapping all of the children he sent to Russia from Ukraine to brainwash them to hate Ukraine. So the problem with that is, when I watch the broadcast on YouTube, is how are you going to enforce that? No one's going to go in and arrest Putin. So they have a court. They said they want to, you know, charge him and face trial. Now, that's the exact same thing that we're talking about when I talk about the government breaking its own law. Who is going to enforce the government's own law when the government doesn't want to? Because think about it. The government could have left the law alone. They could have said, well, we're not going to put Canada Pension Plan Act Section 65(1) into place. We're not going to put Pension Act Section 30 into place. We're going to leave it so that any creditor can go after us and intercept that payment and have the payment redirected to satisfy a debt. Now, the private industry has been asking for this forever. They don't like the government immunity. Okay? They say the government should be on level terms like everybody else, and they shouldn't have immunity under the law they pass. Because all of those laws I mentioned are immunity laws. And I'm not a lawyer, I keep saying that. I'm not detracting from my credibility, I hope. But I know a lot about cases because I've read them. There was a case in 1995, and it was, Christ, now I'm trying to remember some kind of French name, sort of. But the lady who was divorced couldn't get the money from her ex. Her ex left the country. The only asset he had left in Canada was his public service superannuation pension. So she asked the courts to take that pension, order it to be collapsed, and that she will get her share to pay the $300,000 she was owed. The Department of Justice went to court, and they said to the judge, you can't ask this to happen, Judge, because we wrote laws to protect all of these pensions, like Public Service Superannuation Act, Section 10, brackets 10, is a law that the government put in place to specifically prohibit what this lady is asking for. Now, the judge agreed with the Department of Justice, so we know, because it's been to court and there has been a precedent set, we know the purpose of Section 1010 of the Public Service Superannuation Act, which is the same as Section 83 of the Canadian Forces Superannuation Act, which is the same as Section 65(1) of the Canada Pension Plan Act, which is the same as Section 30 of the Pension Fucking Act. So if someone says this is your opinion, it is not. It is the opinion of the Department of Justice, who had it certified, had it agreed with by the courts. Now, it seems like the government doesn't want to look at it that way because, I mean, back in 82, for example, I'm not totally paranoid, but back in 1982, when they were bringing in the Charter of Rights and Freedoms, they didn't want to protect property. The provinces didn't want to say people had the right to property. It's crazy. It's in the Canadian Bill of Rights that you have the right to enjoy and own property, but they wouldn't put it in the Charter of Rights and Freedoms. I mean, it's nuts. Anyway, that's just a side note. Carrying on, the cost of living allowance exception as per the SISIP policy, Section 24B and Shawn. Again, trying to remember which Shawn. I think it might have been Master Seaman, retired Shawn Crane. What it is between 2006 and 2019, the government had a section in the Veterans Wellbeing Act, Section 27.3, that was the same as SISIP policy, Section 24B. Now, Section 24A is the right to claw back in contract things like the Pension Act before it got quashed in court, or the Canada Pension Plan, the Canadian Forces Pension, and all of those other things is listed off in Section 24A. But in Section 24B, they say they won't take the cost of living allowance inflation factor on the clawback into account. Now, I thought about the earnings income replacement benefit problem with Shawn before, but I never thought about putting that and looking at and analyzing, does SISIP owe him money? Because they're not supposed to take into account the inflation factor on his Canada Pension Plan disability or his Canadian Forces Superannuation Act pension. Now, it's not going to be a lot of money, but they should do it as per the contract. Ordinarily, contracts are, bound. You have to be bound to the contract. But they don't. They want to apply Section 24A to claw back things to save money for themselves, but they don't want to apply Section 24B, even though it clearly states they can only take the original amount. So if you got approved, let's say $1,000 a month, 10 years ago, 10 years later, SISIP can only take $1,000 a month into account because of that Section 24B. But they don't. They ignore that. They did in my case, and I'm pretty sure if I contact Shawn, look into it a bit, and then have a look at how much they owe, because I like my spreadsheets, it'll quite $300, $400, $500, $600. But how many people are they doing it to? That is the problem. This could be a class action. It could be a no-brainer class action that could get the ball started, the ball rolling, because I was thinking if we start getting things going, it could be to do it on a couple of easy issues, like the cost of living example I just mentioned. They're not supposed to do it according to the contract, but they do it. Therefore, they're in breach of the contract. Therefore, they lose. Now, once you establish that they can't even, they're too stupid to follow the contract that they wrote, well, then you got them on the back foot. You can bring in other things, right? When you're talking about the clawback and the cost of living, then you can bring in the fact that, hey, maybe you don't have the right to take anything into account at all. And you'd say, well, isn't the SISIP long-term disability policy a non-indemnity and contributory long-term disability payment payable in relation to the premium and subject to the formula? Yes. Then you'd say, well, in the common law, isn't it true that clawbacks aren't authorized for a non-indemnity payment? You cannot claw it back, nor can it claw back things. That's the common law. I got that from a 1994-1995 British Law Review, because they were reviewing how damages and insurance should interact. Okay, carrying on. Truth in a democracy versus law open to interpretation. Now, this open to interpretation thing is like rubbing salt in an open wound for me, because my member of parliament said, and the director of CRA, when I was in having a grievance, the law is open to interpretation when I had accused him of crimes. He said, oh yeah, well, I'm going to leave here if you don't stop accusing me of crimes, because I told him, you broke this law, you broke that law, therefore the Criminal Code Section 226, you're likely in violation of. I'm not going to stand here and be accused of crimes, but the law is open to interpretation. Now, that was back in 2012, 11 years ago. He has still not answered for his crimes, his alleged crimes, the accusations. But when my member of parliament, Seamus O'Regan, said the same thing to me back in 2016, 17, or 18, shortly after he had been elected, and I was over meeting him, and in person I told him about the clawbacks being breaking the law, he said, well, the law is open to interpretation. Now, I've waxed on about this many times, but a lawmaker should not admit to incompetence like that. If my elected member of parliament, Seamus O'Regan, writes a law that is open to interpretation, he has not done his job properly, because laws must be clear enough and propagated to everybody so that they can be obeyed. So when he said that laws are open to interpretation, well, basically he was admitting he was an imbecile. The government should not try to use that argument, that the law is open to interpretation. After all, they write the laws. Isn't that common sense? Okay, again, because I want to get into my letter, and I might have to explain a bit besides just reading it out, I'll get on to the next one, 226. The duty to be consistent. I think the government has a duty to be consistent. Like if two people are in a similar situation, you can't have one person getting treated differently than another. I think it's actually part of the common law system, precedent and all that. It's common sense, too. But what I was thinking of, and I'll bring it up in my letter, is that the government took two companies, or two employers to court back in the early 2000s. The Université de Laval Federal Court of Appeal 2002 case, and the National Bank of Canada Federal Court of Appeal 2003 case. Now, in both of those cases, the insurance company was making a payment to the disabled person. But Canada Revenue Agency, in its infinite wisdom, and I hope your sarcasm meter is on because they were idiots here, they said that the source of the payment is actually the employer, not the insurance company. So therefore, there should be employment insurance premiums taken out. Now, anybody should have looked at that. And they should have said, is the person performing active services for the employer and getting paid on a regular basis for employment? Or did they buy an insurance policy from their employer that they hired a company, the employer did, to administer the insurance policy, and the person is too disabled to perform services? Because anybody who's too disabled to work shouldn't be required to pay into the employment insurance plan. What the fuck is wrong with them idiots when they looked at one issue was the source of the payment the employer? The answer was surely yes. I would agree. Hopefully you would agree. But the analogy I came up with, metaphor, analogy, is something. It's not a simile, because similes uses like. But I figure it's like, and I know I'm making a bit of a joke here, the simile thing. The employer has two hats on. When the person is working, the hat the employer has on has employer wrote across the top of it. When the person who bought an insurance policy from the employer becomes too disabled to work, then the company has a hat with insurer wrote on their hat. So whether or not the source of the payment was the employer or not, it's moot. What matters is, why was the payment made? If the payment is made in relation to the premiums paid in a contract, that is not related to employment. It's related to the premiums that you bought an insurance policy from. No one can get long-term disability insurance without buying it. So you bought it from your employer instead of an insurance company. So Sierra got it totally wrong, but they're not being consistent because the Service Income Support Insurance Plan, Policy 901-102, and Sun Life, Policy 12,500G, I used to get SISIP and I am still getting Sun Life. In both of those cases, they're not being consistent because the government is the former employer. They hired insurance companies to administer the policies. So these are what you call administrative services only policies. And if you treated them like the Université de Laval and the National Bank of Canada employers, then they should be put on the T4A if one is required at all. It affects taxation and it affects our trust in the system. Actually, I'm pretty sure I'm going to get into that in a letter. So that's it for my points from my list, and I'll post them later. Now the second bit I was going to mention, I'll save the changes. Now this is the problem. Whenever I start to, say, write a letter to a member of Parliament or someone else, I think it's going to be nice and short, a couple of points, less than a page. Then I think of this. Then I think of that. And I have an obsessive-compulsive personality disorder. I'm saddled with this thing that I think that, it's not right, if I leave this out. That's a good point, too. So it gets bigger and bigger. So bear with me. I started this on March 14th. So I said, Dear Minister, because he's the minister or something or another. This letter has a few points, but the main idea is to secure your support for the recognition that I was injured in service to all Canadians. Now I'm rubbing it in here. I wouldn't be this wordy for nothing, but this really bugs me. Plus, I've been talking to the member of Parliament trying to get help for so long, I'm rubbing it in pretty good here as far as I'm concerned. And am entitled to compensation that is provided for in law. Now, I'm going to be putting in editorial comments like this. What I'm referring to is Section 2.1 of the Veterans Wellbeing Act. That was put in there in 2015 when Prime Minister Harper tried to buy off the Equitas lawsuit people. So they put that in there that the government's, bound to compensate people who are injured in service. So that's the law. Number 1, point. I request your support, our support to resolve an issue of my having been injured in service, as I have had no compensation for injury since my medical release from the Canadian Force on the 19th of January 2012. To facilitate that support, I list the following evidence of my being mistreated. A. The Department of National Defense Long-Term Disability Insurance certified me as being disabled in service in accordance with Section 41A3 of the contract. B. Veterans Affairs Canada certified me as being injured in service with their Rehabilitation Record of Decision, RROD, on the 13th of November 2012. That guidance on the certification of disability with an RROD is the government must be certain before this, as this cannot be changed later. Now see, I added more to that. It started off simple, but then I added another sentence to it later when something occurred to me. C. The Department of National Defense Financial Services, D&D, and VAC signed a program arrangement in 2006 and updated in 2012. I put in a little jab at him here. I obtained a copy of this from you by email a few years ago. Section 3.1.2 states clearly that SISIP Financial Services is the first provider of income replacement, in quotes. As such, D&D is responsible for any certification of military injury, or perhaps it is moot in the case of medical release under Queen's Regulation Orders 15.01. Well, see, what I'm getting at is that Section 3.1.2 don't say when you get hurt in service. It says that when you get medical release. It doesn't mention injury in service. D. Supporting the last point is VPPN 5, which states that a medical release results in a dual client. One that is a client of Veterans Affairs Canada and D&D. Now, I shouldn't have had to put that in there, but I think they're stupid, so I spelled it out for them. E. With respect to any nonsensical argument that Veterans Affairs Canada has to recertify D&D's certification, the public policy of economical government should be relevant. Why do the same work twice? Is it in the taxpayer's interest? On that note, a one-time payment of COVID relief to the disabled is a great example, as the government first wanted to use the disability tax certificate, but relented under common sense and added others such as the Canada Pension Plan Disability and Veterans Affairs Canada. In a way, this is similar to the solution in the SISIP class action that Canada lost, again, getting a jab in at them. As Canada Pension Plan Disability and Veterans Affairs Canada's income replacement benefit were used as the yardstick for approval for SISIP long-term disability past 24 months. Now, I'll do an editorial comment there, just in case you're not aware. After the Manouche class action, the government said, well, we need to know how many people will be certified. The first 2 years, the 24 months, we're not worried about. But to satisfy the definition of the Service Income Support Insurance Plan, Policy 901 and 102, we need to make sure that you're disabled as per the policy's definition. So they said, you know, the people that were zero-sum, they've been through a lot. So you know what? We're going to use a proxy, they call it. We're going to find other government programs that have a similar definition, and if you have this, we'll give you the SISIP past 24 months. Very sensible, isn't it? I think it is. I might not like the government's, what they do with this and that, and I might not like what McKenna Cooper did in the Manouche case in a lot of things, but this proxy idea is total common sense. It's excellent, you know, work. Anyway, the thing is, the people that are doing these certifications don't want other people to do it because they don't like to lose money and prestige and other things. So they want to have all of the everything. They don't want to share it out. They don't want to have common sense. They will come up with all kinds of excuses to say that it has to be done our way. Anyway, F. With respect to points A and B, the common law doctrine of estoppel arises as the government cannot rescind its certification. Now, what estoppel is that you can't have your cake and eat it too. You can't argue one point and say that it's daytime and then later claim that it's night. You stated for the record it was day. That was your position. You can't have it both ways. Now, that's a very clear and probably not very good example. Let me use one of my own experience. I was involved with a grievance, or a bunch of grievances with Canada Revenue Agency, and my key point in the whole thing was that I was placed into a lower level job, which means that it would have been a promotion to go, you know, back to my old job. So they put me into a new job, but they protected my salary, and therefore I was in a lower level job as a PM1, Program Administration 1, but I used to be in ED education, that means EST, elementary and school, secondary teaching, 01, which is the level. Now, all along for 2 years, CRA said that I was in an equivalent position. I was not in a lower level position, but then just before adjudication, they agreed that I was in a lower level position. Well, they should have lost, because they can't have it both ways. You can't argue for years and say that I'm wrong by saying I was in the equivalent position and then turn around and put it in a written affidavit that I was in a lower level position. Do you see my point? That drove me up the wall. Union did nothing for me, but I don't want to go down that road right now. I'll continue on. Now, okay. Point number 2, because I was going to just do one point, but then I figured I'll try to get support on 2 things. And the second one is for general application, not just me. First one is about my recognition. It might apply to other people, but in general, it's about me personally. Number 2, the second issue I want to secure your support on is the unfair taxation of the disabled under Income Tax Act Section 61F. I have been under pressure to file my taxes. People might look at me as a former tax collector and say, how come you're not filing your taxes? Well, I don't trust them. Okay, I don't trust them because of the reason I'm going to list off, which I told CRA I do not trust. To prove my point, I offer the following evidence. Now, some of this might not be evidence, but it's facts, I guess. A, Canada has a constitution, which is the supreme law of Canada. B, Canada has a Charter of Rights and Freedoms, which includes minority protection, such as Section 15.1, which states that a burden in or under the law must not happen for these enumerated, which means stated, groups. C, Canada has a quasi-constitutional law called the Privacy Act, which is meant to protect the citizen from the overwhelming power of the state when asking for information. D, the Income Tax Act is an ordinary law, and laws are meant to be harmonious as a whole. That's what I was saying before about interjurisdictional immunity and repugnance. They're supposed to be harmonious and not disagree with each other. E, Income Tax Act Section 61F places a legal burden on the tax burden on the disabled, almost certainly a violation of Section 15.1 of the Charter. F, however, Canada left exceptions in the law for taxation of the disabled. Point number I, subpoint I, if the payment is not periodic, then it is not subject to tax. And 2, if the employer does not make a contribution toward a premium, it has to be taxed as if it was a periodic. Oh, what the hell was I saying there? Oh, if the employer... Anyway, the point is that I was trying to make, I'm going to go review it and fix it later to make sure I'm right. To be taxed, the employer must have made a contribution towards the premium. Now, if you pay 100% of the premium, it has to be tax-free. Now, CRA would admit that. That is the design of Section 61F. What? Oh, maybe I'll mention it here so I won't muddy the waters. Okay. G, it defies the law and common sense to think that the employer made a payment out of its own pocket. Perry v. Cleaver, 1969, and IBM Supreme Court of Canada, 2013, document the point that the payment made on behalf of the employee is the payment of the employee, not the employer, undermining the unlawful cash grab made at the expense of the disabled in favor of healthy taxpayers. So, to me, what they're trying to do is lessen the tax burden of the healthy people that are working by taxing the disabled who cannot work. Now that, in and of itself, is abhorrent, crazy, nuts, absurd. After all, the point of Income Tax Act Section 61F is to minimize the tax burden, notwithstanding this is true for all laws. That many laws favor one group at the expense of another. Review point B, however, that is as not acceptable. H, a preliminary objection has to be lodged when the state lies on the T4A tax information slip it issues to itself, which also brings up the charges of self-interest or bias. Manulife is not the underwriter, and I put in brackets, insurer, for the SISIP long-term disability policy that I received from 2012 to 2017, as the courts decided that it was an administrative service only policy with the Chief of Defense Staff as the underwriter. Now, I'm not making that up. That was in the Manouche case. Manulife was stated to be a stranger to the policy, but also was stated to be the commercial partner for the government. Now that brings up bias. They're asking, Manulife is sending in for chief of staff to CRA. They're all the government, and they're ignoring the truth because they want to maximize taxes and ignore the rules. It's nuts. It shouldn't be happening. Okay. Sun Life policy 12,500G is in the same situation almost certainly. The government, I'll tell you why I said almost certainly. The board of directors for the Sun Life policy is the National Joint Council, which is 4 unions and 4 employer representatives and some other person that becomes the chairperson. So it's not exactly like SISIP. The government might try to say that it's not the government's policy, it's National Joint Council's policy. So I put in almost certainly because, well, it's a little bit fudgy. The government of Canada underwrites the policy, because I'm sure they do that, meant for unionized public service, and I have been getting this administrative services only policy insurance since 2009. The T4As filed in the name of Sun Life is a form of fraud, just as the ones from Manulife are. As such, they had to be expunged from my tax file. The legal doctrine states that the courts and indeed the government cannot condone illegality. And then I put in brackets the one I've been quoting all the time: University of Laval, Federal Court of Appeal 2002, National Bank of Canada, Federal Court of Appeal 2003, and I added a third one, the Toronto Transit Commission, Federal Court of Appeal 2010, because that was a similar case, but in that one the government lost. They were arguing, based on the previous 2 cases on employment insurance, that the Canada Pension Plan contribution should also be deducted from the payments made to disabled Toronto Transit Commission ex-employees. Well, the court said no, CRA was wrong this time. Well, the government changed it anyway. 2011, Bill 73, I think. Anyway, so because I'm getting tired of all this, and I could probably think of other points, I finally said I better write up a conclusion, a paragraph. So I said, in summation, I have informed CRA and the government that I have numerous causes not to trust it. Democracy requires trust in our elected officials, government, but it must be earned. What is happening in these 2 issues I have outlined detracts from my trust in Canada. I will remind a reader that I once served in the CRA as a tax collector and as a commissioned officer in the Canadian Forces. The latter is where I identify with most. I was willing to die for Canada, and I take great umbrage with those not willing to die for it lying to me. Will anyone serve if they know that this was even possible? In part, my government service has been a liability, as I know things usually get fixed, given time. However, these issues have not been resolved in over a decade. Where am I? I do not expect a guarantee of success, but I do expect support and effort to remedy this before I have to resort to a legal challenge. Some might think that this would be normal, but why should I have to sue about things that should never have happened in the first place? If this letter serves nothing else, it could be evidence that I confronted the government that I once served, but I prefer to think that it's my duty to report as per Queen's regulation and order, and I put in XXXX because I couldn't remember it, but I'm pretty sure now it's section 4.16 or something like that, where a commissioned officer cannot be a silent witness. So if you're in the military, you can't turn your back when you see something happens. If you have the power to fix it, you're supposed to fix it yourself. If you don't have the power to fix it, you're supposed to report it to the appropriate authorities so that they can fix what you witnessed. There's no such thing as just ignoring things, supposedly. Now, I mean, sometimes you might say, well, who would know? Well, I used to take my duties, even if I was a reserve officer, seriously. And I knew that it was my duty to report various things. I'll give you a couple examples, even though I finished this. I reported to, say, the antitrust people about the insurance companies that are not really competing with each other. because the 4 federal government plans have never been tendered. Now, that's crazy. Normally, you're supposed to tender things. If the government wants to hire someone to administer its insurance, it ought to put out a public tender and see which one, has the lowest bid or can do it best or something. But they haven't. Now, I don't understand why all this stuff is. There's a lot of money, there's a lot of power, and it could be a lot of criminality here. I mentioned a lot of laws being broken. Well, the criminal code has a section in 226 that says if you violate a federal law, you can be charged. Now, it's not considered to be a criminal charge. It's considered to be a regulatory charge, and it can only happen if the law in question does not have a penalty for violating it. So if you broke the Canadian Forces Superannuation Act, Section 83, or the Pension Act, Section 30, there's nothing in those laws saying that you're going to go to jail or get a fine for breaching that act. But everybody knows that you have to have some form of punishment to enforce a law, and Criminal Code Section 126 is that catch-all law. I only found 2 examples of it ever being used. One of them was in 1979, the Canada Post went on strike, and then the government passed back to work legislation. The union told them to fuck off. The government charged and convicted the union leaders with disobeying a federal law and conspiracy. I think those people might have ended up in jail. You can't thumb your nose at the law. Now, getting back to that point about not filing my taxes, I just don't care. Like, what can they do to me? Okay? I'm not working under the table, so I don't have money coming in that they don't know about. They have T4As for my pensions and my insurance. It's just a technicality that my taxes is not physically filed. Now, put that with the fact that I don't trust them. If they had listened to me and done an investigation into the fact that is Sun Life making the payment or is it the government of Canada? Is Manulife making the payment from its own funds or is it the government of Canada? Well, it'd be different because they would have listened to me and they would have started an investigation. Instead of that, I'll give you another example on the final point before I shut up. I thought this would be a good one for the Canadian Forces Ombudsman. So not the taxpayer, but who is the underwriter of the SISIP policy. So I called them up one time. I asked them about it. They called me back a month or so later, and they said the answer is Manulife. I said, give me a break. How are you saying that? Well, that's the way it is. I said, listen, don't you know that it was in court and they said that the Chief of Defence Staff was the underwriter? Now, if the Chief of Defence Staff is the underwriter, how can you say with a straight face that Manulife is the insurer? So I think it's all a big old cover-up. Why didn't the Canadian Forces Ombudsman start an investigation? Because I thought if they started an investigation about who is the insurer, it would start ripples, like a rock thrown in a pond. Why are they lying? I think, and I probably said it before, you might have remembered, and if you weren't, I think that the Manulife is defrauding us and the government. Because if they're allowed to take the Canada Pension Plan into account, it's supposed to be so they reduce the government's expenses. I think Manulife is keeping the money. And all the other insurance companies across Canada are keeping the Canada Pension Plan disability money. And I can't help it the way my brain works. I'll mention one other point about that. If you're going to get the Canada Pension Plan disability, they make you apply. When you apply, they make you sign an irrevocable consent form for CPP to send the money directly to the insurance company. Now, if the money goes directly to Manulife, it is my contention that the Canadian Forces Pension would not be able to say you owe them money for bridging. Why? Because the money went to somebody else. The letter from the Canadian Forces Superannuation Act says, pension people says, our headquarters has been advised that you are now receiving the Canada Pension Plan disability and therefore you owe us this much money. but you never got the money. The irrevocable consent form that you signed made it go directly to Manulife. Now, if you had gotten the money, they might be able to assert that you owe them money. But you can't say that somebody owes you money when they got money, when they didn't fucking get the money. I hope you see that, right? Then to add insult to injury, Service Canada sends us a T4AP form to the disabled veteran, in this case, because they're disabled, to count the pension by disability, but disabled people. Now, the money never went to the veteran, it went to Manulife. But the tax bill goes to the veteran. I'm waiting for a response because it's fucking dumbfounding. You can't be taxed on money you didn't receive. I shouldn't have to explain it, but it's common sense. If you're going to get a receipt of money, tax may apply. But if the money didn't come to you, don't try to tax money that I didn't get. Well, geez, you're just making shit up now. Right? Now, I could quote off a 1972 Supreme Court of Canada case that says the very same thing that I'm saying. But unfortunately, I can't remember the name of it. I do know the year. I do know the level of court. But I know that money must be received and enjoyed in order for someone to try to tax you on it. But again, going back to the other point, one of the key principles of Income Tax Act Section 61F is that the employer must make a contribution. Now, the Perry versus Cleaver and the IBM cases, well, you paid for it all. You paid for some of it, which was deducted from your pay. That's the 15% that the government says that the soldier pays. And the government states that it pays 85%, but that is in relation to service. And it's the same as pay. So really, you paid 100% of the premium, so we go back to that principle that if you pay 100% of the premium, you cannot be taxed on it. Doesn't matter if the payment is periodic or not periodic when you made 100% of the premium payment yourself. So they're trying to rely on the technicality that the government made the payment, but that's where we go back to the National Bank of Canada and the University of Laval case. That wasn't okay there. They didn't look at what really happened as a fact, and they looked beyond that, and they said, well, even though Manulife made the payment, it was really the employer. Well, let's look at the premiums instead of the insurance. Even though the payment was made by the insurance company, was the actual payment coming from the employer? I got mixed up that time. The premium. When you pay the premium to get the insurance, to buy the insurance, the employer pays 85%, but is it making that payment on its own behalf? Or is it making that payment on behalf of the employee? See, it's just nuts to think that the employer can ever pay a contribution towards an insurance policy or anything, really. Look at the pensions, the Canadian Forces Superannuation Act pension. Some money is taken off your check. That's considered to be your contribution. But the government puts in money too, and that's your contribution. Because it's delayed pay. Pensions are deferred pay. Now the government thinks that it's making a payment out of its own pocket. And that's why the government took the surplus years ago. There was an actuarial surplus in all the federal pensions, so the government decided to use it again to bring down the debt a bit. So they took the property of the public servants, the Canadian Forces members, and the RCMP members, and they stole it to pay down the debt. And it didn't help that the Supreme Court of Canada agreed with them, the pricks. That's one of the cases that caused me not to trust the courts. The other one was the Arthurson Supreme Court of Canada 2003 case, where disabled veterans who couldn't manage their own affairs. So Veterans Affairs Canada was looking after their pension act in trust. That made them a fiduciary. They didn't give interest for over 50 years. Okay? You can't look after somebody else's property, have it in the bank, and not give that person interest. So Supreme Court of Canada overruled the Ontario Court of Appeal case, which gave the judgment to the veterans. And they said that when the government writes specific laws, even though we think it's crazy, to expropriate someone's property without compensating them, they can. Bull fucking shit. You cannot take someone's property without paying them for it. Now, if you're taking someone's land to build a road, and you're doing it for the greater good, you pay them fair market value, and Bob's your uncle. They might not like the payment they get, but they got paid compensation for the property they own. In the case of those disabled veterans who couldn't manage their own affairs, the Pension Act payment was their property, and they got interest, which was what the case was about. The interest was their property as well. So basically, the Supreme Court of Canada let the government of Canada rob veterans that had been fucking over for 50 years. Shouldn't have happened. They should have said, you lose to the government. No one can take this from people. And you know what? You did this as veterans who got injured in service to Canada. Instead of paying $1.07 billion, which is what they owed, you pay $3 or $4 billion, you fuckers. Don't ever do it again. That's what they should have said. Instead of that, they looked at the taxpayers' interest, I think, and they threw the veterans under the bus. I saw that at first in 1987 in the Hazard. I wasn't looking at it back then. I was only reading it last years. But they have been discussing that issue. In 1987, up until 2002, when the case went to the Ontario Court of Appeals, and then it went to the Supreme Court in 2003. And really, one of the points, I can't help it, I've said it before, in the Otherson case, they had a lot of documents there about when did the government know about this problem that, they weren't paying interest to the veterans. And they said they had an internal memo from 1985 that stated about this problem, here are 4 possible solutions. Point number 1, do nothing. Now, why didn't the judge say this is a government document recommending solutions for disabled veterans who couldn't manage their own affairs? And the first point was do nothing. Find out who wrote that and throw him in jail. That is a crime. It's called breach of trust by a public officer. It is section 122 of the Criminal Code. And it's about when someone does something that is so far beyond the pale of what is normally expected from a public officer that they breach the trust of the government. That's what should have happened. Point number 2 was take each case as it comes up and deal with it. I don't remember the other 2. But number 1 was basically a cover-up. Do nothing when you know about a problem? This is the problem that I keep railing about. You can't simply do nothing. It goes back to Queen's Regulation 4.26 that I was talking about. You can't look the other way when you're aware of a problem. Another fine example of that, and I wish I could stop thinking of this shit, is the $100 million payable to veterans under the Pension Act between 2003 and 2010 when they didn't use the wage index and they used the consumer price index because they never thought about using what was legally required under the Pension Act. Because the Pension Act states that the cost of living allowance that's going to be placed onto the pension for inflation is the higher of the wage index and the consumer price index. Now, Veterans Affairs Canada decided to put only the consumer price index. Now, it boggles my mind that wages were higher than inflation. It does. Color me pessimistic. But for those years between 2003 and 2010, wages rose higher than inflation. And the government should have increased the pension by the wage index instead of the consumer price index. But they knew about it, and they didn't do nothing about it, which is exactly the problem that I keep coming across. Listen, thanks for watching. I've been almost an hour again, and I'll probably try to go see the MP next week, and I tried to call him twice today, but I never got through, so it doesn't take much these days. I just said, the hell with it. But that letter I just mentioned, I'm going to email it, or I'm going to bring it in personally. And then I'm going to sit down and make them, listen, I'm going to make them tell me they support me. I'll say, do you see my point? I have this letter, and it states from Manulife in 2012, we can't pay you long-term disability because you had to prove you were hurt in service. Eventually, I got paid my long-term disability. You can infer the fact that I was injured in service because they're not going to pay unless they got to. So, I mean, I'm not asking for the moon. I'm asking for them to apply common sense. The proxies are very important. The COVID relief thing, that was a very important precedent. Might not have been legal, but it was what they did, which is what precedent can be. Anyway, thanks for watching, and hopefully we'll get this fixed one of these days.